Namaskar, everyone. Welcome to a new episode of the channel See You Soon. In this time of corona pandemic, it's always our endeavor to bring some positivity and introduce you to the legal luminaries of our country, not this country, but the world over. And with this small initiative, we try to bring about legal knowledge, not just for lawyers and the young law students, but also to people from the society at large. Today, we have a very special guest with us, Mr. Atmaram Nadkarni, sir. If I may briefly introduce, sir, I must tell you that he has been one of the youngest lawyers in the country to have been decorated as an Advocate General from the State of Goa, a position which he has headed for about 11 and a half years. Thereafter, he was also the Additional Solicitor General in the Honorable Supreme Court of India from 2016 to June 2020. He is also eminent senior lawyer of the country and appears in many landmark and high-profile cases. With this brief introduction, may I extend a very warm welcome to you, sir. Thank you for taking your time out and placing our young lawyers and young guests for this channel. So before I start the question answer series, as a matter of custom, I always ask our guests to please shed some light on the early education of in your life cycle, where you had your early education, and how did you decide, and what was that moment in your life where you took a decision that you want to study law and become a lawyer?
The early education basically was, that time in the 60s, there were Marathi primary schools. And you won't believe it, there was no electricity in Goa that time, except in Panjim city. Okay, and this was the factual thing. So we had to study virtually with the LL.M, which was running on petrol. There used to be those old style petrol max, if you have seen those petrol lights.
Yeah.
It's only later that Goa got electricity, much later. Prior to that, only one or two cities had electricity, not all. And that was the primary education in Marathi. Then I went for 5th standard English till SSC, and then I, of course, joined arts, finished my BA, and then did my LL.B and did my LL.M. So that is how it is. Basically, since childhood, my parents, both my parents, my father and mother, wanted me to become a lawyer.
Very interesting. No, so at least you are keeping the dream alive, and by at least contributing every day to the jurisprudence of the country.
Basically, they put it in my head that I should become a lawyer.
It's a very interesting fact you have just narrated, that in the 60s, no electricity and the hard work and the toil that you have to undergo. May I now come to the phase of your life when you went to law school? If you can just shed some light, how were those formative years of being a lawyer, especially when you were undergoing your LL.B degree? And why I ask this question is because a lot of our listeners are also young lawyers, budding lawyers, and young fresh graduates. And I know the world in the 60s and 70s was very different that we see today in 2021. But in your time when you were studying law, I'm assuming it was a 3-year law degree, because at that point in time, one would do undergraduation and then do a graduation.
You're right. 5 years was not even thought of at that stage.
So, sir, if you can just shed some light.
In the early 80s, you had to have a graduate degree. And the 3-year LL.B course was like a postgraduate course, meaning it was after graduation. To enter LL.B, you had to have, a graduation in any discipline, maybe BA, BCom, BSc, BE, whatever. And it is thereafter that this +5 course came in, which was introduced with the intervention of the Bar Council of India, University Grants Commission, etc., much later. So when I joined and when I passed out, it was only 3 years degree course.
So, sir, if I may ask, what was the first degree before you did law?
I did my bachelor in arts with entire economics. So it is what you call the BA honors degree at that time. Okay. Now, the difference is this, that after 12th, when you join law, the 5-year student does not have that much maturity, which a person who has graduated would have had.
True.
See, I'll just add a caveat here. I'm not saying that a person who has passed out 12th and person who has passed out graduation, the later is always brilliant or more mature. I'm not saying that. I should not be misunderstood to say that. I'm very clear. I'm only saying that chronological age, one of the assumptions of the chronological age is there is more maturity when you are at a particular level and entering a degree course. Similarly, you have had one degree, that is bachelor's degree, a 3-year degree course that you have gone through. And therefore, it is expected of you that you will have more maturity to deal with the legal subjects. This should not be taken by +5 students to be something against them. Not at all. +5 students are highly brilliant and I have very high regards for them.
Very interesting point. Very interesting point, sir. In fact, I have a follow-up question from this observation. Because today in our country, we have both the systems where a 3-year course is also being provided and a 5-year course is also being provided. However, I think the reasoning behind starting a 5-year law course was that it was felt, I think, by the Bar Council and other state bar councils that perhaps the 3-year law courses, you were mushrooming across the country and were not performing or were not contributing to the industry as one would have envisioned at the time of proposing a setup for those 3-degree courses. However, today, I think we are one of those very few countries which offer both courses. You can have it after graduation. You can have it after you pass out of school. I don't know if it creates too much of a confusion or if that gives the right choice. Sir. What is your take on that?
See, it is like this. Undoubtedly, LL.B was a professional degree course. But unlike engineering or medical, where there was rush for, the people who used to go for LL.B were those people on the verge of retirement. And LL.B, those colleges, 3-year degree colleges, were either late in the evening or early in the morning,
right,
to accommodate those people. And it's only at the fag end of that you would decide, all right, let me do LL.B, and then people would join. There were very few who were determined to do LL.B and to practice on the threshold. But introduction of +5 course is a great thing. In fact, it has brought in a lot of professionalism in the degree course as well as our profession. The only thing is this +5 students, the trend as it shows, many of them are not interested in litigation. They are interested in joining some corporate firms. I mean, that's my personal observation.
No, I think that's also a constant complaint that I've heard from all quarters, be it academia, be it litigation, be it judges, that perhaps the whole concept of 5-year law school has bent a little more towards the corporate sector than towards the judiciary or the litigation. Having said this, let me come back to your journey when you're starting out and when you were studying your LL.B degree. And if I'm not mistaken, sir, please correct me if I'm wrong. In one of your interviews, I think I could understand that for your LL.B and for your LL.M, you had to move to Bombay University because at that point in time, State of Goa did not have any colleges to offer LL.B course.
No, the State of Goa did not have any university.
Oh, okay. Right.
To be very frank, State of Goa did not have any university. University in Goa came much later.
So, sir, how was the transition? Because as a young person,
Goa was always affiliated to Bombay University.
Right. So that's a good.
When I did my BA, it was through Bombay University. When I did my LL.B, it was through Bombay University. And for LL.M, I migrated to Mumbai to do LL.M there.
Okay. So, sir, when you were studying LL.B, was there a concept of internship in the 80s? I mean, like today, most of the colleges have this curriculum that you have to do compulsory internships, be it with a law firm, be it with a company, be it with judges, be it with lawyers. But back in those days, when you were a young law student, any concept or how would you go about training?
In the 3-year LL.B course at that relevant time, there was no concept of internship.
So you had to really find your own way.
You have to find your own way. In fact, many of my colleagues, they never joined anybody. They straight away started practicing, and most of them are very successful.
Right. Thank you very much, sir, for shedding that light. The state didn't have a university because because I as a person who was born in the 80s and grew up in the 90s, and it's so nice every time speak to somebody elder. We get to know so much about the country also, and how the education, especially the legal education, has developed over the years. And you said, sir, for your LL.M, then you moved to Mumbai. So how was life back then? Because what we envisage today as youth, when we think of Goa, we think of beach, we think of holidays, we think of fun times. But back in those days, when you had to move from Goa for purely education purposes to Mumbai, how was the transition?
No, when I finished my LL.B, I decided I'll do LL.M. Choice was moving to Bangalore, Bombay or Delhi. Bombay was the nearest, so obviously I went to University Department of Law.
Yeah.
And that is where I joined LL.M course.
Right, and it must have been for 2 years.
Yes, it was a 2 years course, and simultaneously started practicing in Bombay High Court.
Excellent, sir. I would like to now, start with that phase of your life when you started practicing as a young lawyer. So please tell us which was the law office or the law chamber that you joined, and what was the role of your senior as a mentor in training you as a young lawyer, and how was the time to start in the profession?
I initially joined a solicitor firm called M V Kini Co.
In a very, very famous firm in the country.
Very famous. Yeah. So I was there for about 8 months or 9 months. Thereafter, I joined a counsel, Mr. Bhimrao Naik, who later became a judge of the Bombay High Court. And in fact, his sons today, 2 sons, Vineet and Amit, are both practicing in Bombay High Court.
Yeah.
So that was the journey insofar as chambering is concerned. I must say both seniors in the solicitor firm as well as with Mr. Bhimrao Naik, they were excellent. They really guided well. But in this profession, nobody teaches you. Nobody taught us. Nobody taught them also. You have to learn on your own. There's now no substitute for hard work, sincerity, and being focused in this profession. These are 3 essential ingredients. And if you are a good lawyer with these 3 qualities, then nobody can afford to ignore you. The litigious population cannot afford to ignore you.
I think that's a very valid point.
There is also a place for a good lawyer at the bar.
I understand, because these are the nuggets of wisdom I think that we young lawyer needs also, and hopefully also the viewers who are going to hear this episode. So my follow-up question is, because you said you worked in 2 different offices. One was a solicitor's office, and subsequently it was a barrister's office, if I can term it like that, because subsequently your senior who also. And so, sir, my question that arises out of this is that Mumbai still, I think, has a solicitor's practice by and large. Do you think in today's day and age, when in the country as such, we have this concept of advocates, and do we still have law firms who are acting as solicitors firm? Because when we speak of solicitors and barristers, it's mainly a UK concept, because UK has a very clear divide of solicitors who can appear, I think, before the lower courts, and barristers then who argue before the appellate court there. But in India, we have advocates and senior advocates. So do you think we still need a solicitor as a culture in the country, or advocates as general breed of lawyers can both man a law firm culture and a court culture?
No, basically, the solicitor culture, you are absolutely right. We got it from London. So in most of the latest patent High Court of Bombay, Calcutta and Madras, you have this concept of the incorporated law societies dealing with the solicitor firms.
Yeah.
Now, the solicitor firms are basically, big like an ocean, and they have a sizable practice. They recruit a lot of law clerks, juniors, etc. They are basically instructing attorneys. For example, a counsel does not deal with the client directly. The counsel does the work of arguing a matter. So for a counsel, there is very less paperwork, but it requires more reading. You have to be apt and ready with the latest Supreme Court judgment, High Court rulings. Whereas for a solicitor and the people in the solicitor firm, it is all basically the paperwork, drafting it out, getting it settled thereafter from a senior, then filing it, managing to get it listed, all those kind of things. So it's basically an essential paraphernalia. Because if you don't have the solicitors to do it, you will have advocate on record today who does the same work basically.
True, true. So, sir, after Mr. Naik's chamber, did you initially go independent? Did you work in any other office? If you can shed some light on that journey of your life.
Oh, I went independent. Thereafter, I went independent.
And you came back to Goa to practice?
I came back to Goa.
Right. So I would just like to question, because I keep often getting asked this question from young lawyers, that when you go independent, any lawyer for this matter, how can one start generating a clientele? This is a question, most popular question asked of me, and I don't think I'm the right person to answer this. So I'm going to put this to you, if you can shed some light on that.
I'll tell you, when I came down to Goa, I was basically from Goa. Plus my father-in-law, he had been the former Advocate General of the state, the first Advocate General. So he was already a senior advocate practicing. So initially, I must say and admit that he was a lot of force and strength for me when I started my practice in Goa. So I can't forget that, because one has to be very grateful and express gratitude to the people who have helped you in life.
Yes.
But all said and done, whether it is father-in-law or father, even if he is a Supreme Court judge or Chief Justice, can't push you beyond a particular extent. It is later, they can give you an initial push. It is later that you have to take on. Because when you argue a matter in a court, the other side lawyer or the judge is not going to say, you are so-and-so's son-in-law or so-and-so's son, therefore I give you an order. That's not the way, that's not what happens in our country. In rare cases it might happen, those blunders and aberrations, but it never happens. Generally, it never happens. So therefore, initial push in the profession is required. But I'll tell you, there are large many seniors who have given such push to many people. You have very many successful lawyers today in the country who did not have their father or mother as or any father-in-law as from the legal profession, but they are very successful. That's because the concept of hard work, integrity, sincerity, focus comes in.
I think it's a very important point that you've raised. Ji.
This is a profession where you got to work like a horse and live like a hermit. Of course, into bracket, the hermit is a royal hermit. It's a Rajbhog. It's not a sannyas that you do like a sannyasi. But you
So very rightly put. In fact, I have a follow-up question from this observation, because you rightly said you still have to put in the hard work. In fact, I have a lot of friends from my batch who come from good legal families, but that does not take away the part of your individual merit, the amount of hours that you have to put, because no client will take you for granted. And such is the nature of our profession, because every day you are tested on whatever matter a client chooses to engage you. And it's a profession which requires utmost sincerity and hard work, as you rightly put. Now, sir, one question that I have again from our young audience who keep asking me is, and how to go about, especially when you're young and you have received a matter or received a brief from a client, and let's say the resources perhaps at your disposal may be limited. You may not have a law library. And then I'm not talking of today, I'm talking of for the time when you were just starting out. Though you had some assistance and some help from your family or extended family. But how many hours generally should a young lawyer put? Because we all have 24 hours, but some people say maintain a good work-life balance. Some people say work for 20 odd hours. So what is the right ingredient? One, to be successful in the profession. Number two, because client comes in phases. It's even what I've realized as a lawyer. You may get a client who may require you to argue a final argument matter. You may have a client who may ask you to do a trial. Some client may come to just take an opinion. So the continuum may keep breaking. So it very rarely happens when you will have a client from start to end. And that's the problem, I think. I don't know how prevalent was that in the 80s, but speaking of today, this is a very frequent problem with young lawyers. So how do we handle that?
Yeah, I'll tell you. See, basically for a lawyer, the gestation period in this profession is a bit long. Unlike for a doctor or an engineer or architect. Here it is a bit too long. Because, you trust the doctor with the body and he gives you medicines, but those are well-known things. In the rarest of rare cases, you go for second opinion, etc. Now here, especially if you're practicing at the High Court level, that's the last court in the state. Everybody cannot afford to go to Delhi to approach the Supreme Court in every matter.
True.
So the training of a lawyer in the real sense of the term must start at the LL.B level. When you seek admission for LL.B and when you are in first year, second year, third year, I tell you, Sanjay, my own experience. There's several students in my class, and I used to be very fond of, apart from general reading, I used to read. I never relied either upon those 3 test papers or that other, that Jabwala series, those kind of things, where it was ready-made answers and ready-made questions and you can this one. Because ultimately, I knew that I have to practice in this profession. And to practice in the profession, you have to be thorough. Your elementary principles of law have to be very sound. Your fundamental principles have to be very clear. So I used to read a lot of the student edition books. I used to read a lot of these reference books. But I had many students in my class, some of my age and some of those seniors. I mean, like those people with advanced age, but that's what I mean by seniors. They used to come and tell me, why are you taking so much trouble? Why are you reading these big books and all that? So, and many of them I've seen today practicing in trial courts, etc. So tomorrow, for example, a client comes to you, you should know what is his remedy. Which law gives him what remedy?
True.
If it is CPC, what kind of suit? If it is transfer of property and mortgage suit, what kind of suit? What can be? So for that, you've got to know the law in and out well. You can't afford when the client comes, oh, you are a matter under the transfer of property. So let me start reading CPC now, then I'll go to transfer of property and then I'll decide. You can literally see the funeral of that person going in front of your eyes if you do that. So, there are, I mean, I would, but I must tell you, there are lawyers of that type. There are lawyers of that type.
I think it's a very interesting point. Please.
Person who had joined with me, asked me, and he was very honest because I like him because he's a good friend even today. He said, sincerely, tell me all these books which are there in the lawyer's office, you think he has read it? I said, no, it's not that, he is to read everything and all that. But only when the reference comes, he has to take it out. So what do you mean reference comes, he has to take it out? What did there are here about? He has got 500 books, so he's got 500 references. I said, no, it's not like that. You buy the books in a series, the whole series comes and that is how it comes and all that. He said, I'm also wondering, he says, that man was born somewhere in 60s and why is he having books from 1901 here and all those things? So you have this type of people also in our profession. You have that kind in all the professions, but you must know that these are all sincere, genuine questions which they have.
I think it's a very valid point that you have raised, and rightly the suggestion that you have given is always prepare for the future, because I personally believe that no education and no reading goes for a waste. We always end up learning something new, and when a client comes to us and if you are prepared and not ill prepared, it only helps going forward in the future. Now, so let me come back to that phase of your life when you had the privilege of being the youngest Advocate General for the State of Goa. I think, if I'm not wrong, you were 36 or 37, which is considered still very, very young to be at the bar. So how was that experience, sir? Because you have held that post for over a decade. So please shed some light on that experience and your learning from that experience.
See, it was basically the will of the providence, I must say, and God's grace that I was offered this post at a very young age, at the age of 36. So obviously I felt very thankful, grateful and felt blessed at that time. But it was a very tough thing because you had so many seniors against whom you had to appear. Because you are being the Advocate General of the state, you are the first law officer of the state.
True.
And judges look up to you for a solution. Judges look up to you for proper assistance and for proper guidance. Because you are not just a lawyer for the state. You are not one of the lawyers for the state. You are the law officer. You are the Advocate General for the state. So at times, there could be times where you have to give your submissions, make arguments which may not be in, in tandem with the policy of the state.
True. So that is one thing. And I think when you're young, and you rightly said, there are so many other senior members of the bar who are opposing you. And sometimes I think experience some way outweighs the youth or the exuberance of youth. So when one is young, the inexperience is also there on the side. So how did you tackle that lack of experience? Because it's a big post. You are representing, you are a representative of the state. You are the highest officer, for a particular, government. You are representing the government. So any interesting anecdotes from that journey? Because I know that I'll come to that question later.
Several anecdotes. One of the things, in our profession is, if you think by an inch and speak by the yard, there are chances that you'll get kicked by the foot.
True.
So, whenever you argue a brief, the first mantra is master that brief. Master the facts in the brief. Okay? And this is very important for juniors, because the senior does not have the same inclination and the time to read a brief as the junior would have. So therefore, every junior in the profession must read the brief from page A to Z. Make their notes, etc. Now, as a young advocate general, I used to always respect the opponents. But what happens is, you are young, you are appointed at that time, and there are so many seniors and stalwarts. So the question of jealousy was there.
True.
And there were many seniors who wanted to show that, look, this young advocate general lost against us. But unfortunately for them, it never happened. I succeeded in most of the cases because I was always prepared in my brief. And if the senior or the other lawyer had a point, and there was a point in the petition, I always considered and told the judges that this judgment is against me. This is how it is. This petition is deserved to be allowed. I never bothered about those things. And I was very clear in my approach to the governments also. Fortunately for me, all the 2-3 chief ministers that I had were such persons who respected the law and who respected the office of the Advocate General.
So I have a follow-up question, because you are the highest officer for the state when you are the Advocate General, and many a times it happens that once, let's say, a case is either won or lost. I'm not on that, but one of the party decides to appeal, and if it's the state who wants to go and appeal to Supreme Court, you may personally feel, in your professional opinion, that this case is perhaps not fit to go to Supreme Court. So how do you then advise your client, which is the government, that please do not go to the Supreme Court? Because sometimes I feel, while representing the government, I've represented state of Rajasthan in the past in Supreme Court, and now I'm also representing the central government before the Delhi High Court. So there are times when I also tell them, look, I don't think this case is fit enough to be appealed. Don't waste the resources for the government. Don't waste the valuable time of the court. As it is, judges are hard pressed for time. So when you are, sir, the Advocate General, how would you convey this message, especially for those matters in which litigation can be avoided?
Normally, as an Advocate General, when you get the brief, you always inform the government well in advance that, the fate of this brief, either the law is supporting you or law is not supporting you. True. But there are certain times where cases are arguable and the government wants to make a particular policy or a particular law for X, Y, Z good reasons in public interest. And the court may find that it is not so. In which case, you have to take a call whether, if you feel that the judges are right in deciding that, then you can inform the state that they are right in deciding that. But whether or not to go in appeal is the prerogative of the state government, which is the party. You as a law officer would only advise that, it's a fit case for going in Supreme Court or not a fit case for going in Supreme Court. But it is up to them what to do.
Right.
Invariably, in my cases, all my advisors were always accepted.
Ji. So my next question is, because you have also adorned the role of the Additional Solicitor General of the country. So one, how was this different being in Supreme Court and leaving your home state? And what was the experience like? How different was it from being Advocate General for the state of Goa for such a long duration? And then, because when you make a transition, not only are you changing cities, you are changing courts. So how was that experience for you?
Yeah, see, I must tell you, even as Advocate General of the state, I was appearing in Supreme Court as Advocate General for the state and in lot many private matters also. So Supreme Court was not something new to me, because even as Advocate General, I had appeared in Supreme Court.
Right.
The only thing which was new for me was the post of Additional Solicitor General. The essential difference was, as Advocate General, you are the first law officer. Whereas the first law officer, there is the Attorney General of India.
Correct.
Who marks the briefs. And you have to argue that brief which is assigned to you. Whereas as Advocate General, you can choose to appear in any and every brief, whichever brief you want. So there, basically it was different, because you are not the first law officer. You are the second or third law officer or fourth, whatever it is. So those were the differences. So far as arguments are concerned, it's one and the same. I mean, the only difference was, instead of arguing before the state high court, you are arguing before the national Supreme Court. That's all.
Right. So I have a follow-up question which arises out of this and more out of curiosity, which is because as a long tenure, when you're serving the government, be it a state government, be it a central government, you are privileged to read so many laws and statutes, which are challenged almost on a daily basis. In your personal opinion, have you come across as any laws or number of laws which you think are completely redundant and should be done away either by the central or the state government, because we have too many laws in the country?
Several of them. India is a country where there are, the number of acts is something runs into several thousands. You can know it. The Indian Constitution was framed in 1950.
So
we are in the year 2021. So this is the 71st year. To amend the Constitution. Some of the provisions required, 2/3 ratification by the states also.
Right.
But despite that, the way we go for constitutional amendment, at the drop of a hat, we go for constitutional amendment. So today we have crossed the century, long back. And many more have been introduced also. Many more will be introduced. I'm only telling you how immature we are to deal with, such a great document, Constitution of India, prepared by taking such good cudgels by such brilliant people. And at the drop of a hat, just because some law secretary or somebody suggests something, we just go for constitutional amendment. It's very, very, it becomes a very difficult thing. You have to trust the government to handle the constitution properly.
Right. So that's a very valid point, that not at the drop of a hat can be changing the constitution or other statutes. So my next question is, now that we are in the era of pandemic and because of your busy schedule, I know that you appear in a number of matters. How has the experience been for you appearing virtually? Do you think this is the way going forward? Or do you think a hybrid model would be an ideal model in the days to come?
Jay, I must tell you very frankly, because it was not possible to hold physical hearings, the endeavor of the Supreme Court and other high courts and other courts to have virtual court was a good thing. It is a very welcome step and one must compliment them. However, that virtual hearing can't be, the rule for all times to come. Because in big matters, people don't get, it is not possible to argue a matter with the same ease and so smoothly as you would be able to argue in the open court. 2, unstable internet connections in this country. 3, from an industrial age, we have gone to the information age. But unfortunately for India, even Supreme Court, you must have heard yesterday, the Supreme Court rose up because that connection was unstable.
There was a glitch, yes.
There's a glitch. So what I'm trying to tell you, if it happens in the highest court, there's an order passed by His Lordship Justice Sanjay Kishan Kaul. Very good order, talking about Supreme Court's system. And he says the next door Delhi High Court has such a good system. Why are we not able to have that particular system? So all those things are there. These are issues which basically their lordship should sort out. It's not something which should, be an issue between the bar and the bench, etc. These are all hiccups, minor hiccups. This need to be sorted out. But surely it can't be the rule thereafter that it will be only video conferencing, etc. It is true that some of us, especially seniors, can sit at one place and appear in different high courts. That's okay. That was this particular time. But the demeanor of the full-dressed court hearing is something which is appropriate. And that is what must be started again.
So I have one or two more questions before we come to an end of the session. So then follow-up question I have is many times the normal public also has a huge outcry saying that there is a delay in our court system and the justice system takes time for any case to come to a proper conclusion. But sir, I'm going to put my question specifically to you regarding Supreme Court. Being the highest court of the country, they have a sanction strength of about 32 judges, out of which at any point in time we have a sitting strength of 22 to 24 or maybe 25 judges, and then judges are retiring, the new judges are also sworning in. So what do you think should be the right approach? Do we need more Supreme Court judges today more than ever, or do we need a court of appeal which can bridge the gap between the High Court and the Supreme Court? What, in your view, is the right way forward?
See, basically, I'll tell you, the Supreme Court judges themselves seem to be doing a lot of hard work. If you see on a miscellaneous day, they read about 50, 60 matters. And some of the judges are extremely good. They read from page 1 till the end. I've seen that myself. So when you argue a matter, you know when the judge tells you X, Y, Z. There are judges who just take the brief and they are not ready to hear you because they have already read the brief and they throw it out. That's completely wrong. There are judges who give you very patient hearing. Even if they are against you, they give you a very patient hearing. Their demeanor, their disposition in the court, etc. is fantastic. And there the lawyer is comfortable, everybody is comfortable. So, I mean, what is required is basically the hearing should be given to the parties. Parties must feel, that look, my lawyer was heard. Of course, it's a completely frivolous, faltu case, then there is no way. But if somebody is trying to make out some point, you must always hear him or her. Why not? You may be in a hurry to finish all the matters and go home early. That's not the reason that you can do it.
Sir, do you think it's high time that the country had at least more than 30 judges? Should we have about 100 judges, 150 judges? I don't know, just a random number I'm putting out there.
150 at the Supreme Court level are not required. If you just have the 35 judges today which are doing, if they do a proper job, then the pendency in the Supreme Court can come down.
So the second last question I'll put to you is that many times it's seen that even in the lower judiciary and in the higher judiciary, we have a lot of programs for judges training. There are a lot of benefits for learning the law, senior lawyers coming and teaching them. However, I think so far as the litigation arena is concerned, young lawyers sometimes do not have that benefit. Just like the Judicial Academy where they will get training, or in like biggest law firms in the world or even in the country where you have a continuing legal learning program. So what is your thought on that? How can we together devise a program or a system where young lawyers, new entrant to the bar, can be taught of these nuances, how to read about judgments, how to assist judges, how to be more productive in their chambers? Because even at the chamber practice, at most a person would have 5, 10, 15 juniors. But then there are so many other good lawyers out there who can do with some good guidance. Sir. What is your thought on that?
See, that's a very good question. But then it can't be straight answered. It will have so many mixed answers. Because it depends upon basically to augment the disposal or even to bring about a different system of practicing law. You need a complete change in the mindset and the culture. Tell me, Jayant, how many you have seen read the brief fully?
Now, if I must say so, the old saying is between the lip and the cup.
Let the judge only decide, because if he's with you, he's going to decide. Why read the brief? That can be the attitude. When you get the work, you have to do justice to that work.
So the idea is an overall change requires, I think perhaps it should start at law school level, the law college level, because I think if they have more guest lecturers, because we have to nip it in the bud, because if we have non-serious lawyers, it puts a dent on the image of the profession as such. By and large, and people say, if I can say it in Hindi, ki vakil to aise hi hote hain. Kai baar, sir, I get to hear this term, and it's very enraging, because I know there are lot many good lawyers and good number of judges who are putting man hours in the brief, doing good research, and then making excellent arguments in the court. So as you rightly said,
even dressing habits as a lawyer, your band, your attire, your coat, your shirt, how you dress, how you conduct yourself. What if you see a lawyer wearing a band or something, and he is wearing chappals and coming to the court? I mean, what impression will the whole world carry of this profession?
It is very true.
So it's
very true.
Like that,
So just my last question, and we towards the end of the program always request for closing comments, sir. And if you can just say something for our young guest. And when I say young, sir, I don't mean just the age. I also mean young in mind and young at heart. So what are the closing comments, sir? We had a wonderful session with you. So much of positive knowledge and the insights that you gave.
Basically, my closing comments is the younger generation today is far more exposed. When I had my education till LL.B, there was no television in India. In Delhi, it came somewhere in 82, 83 during Asia. And thereafter, in 86, 87, etc., it started coming in other parts of India.
Yes.
But otherwise, television came for the first time in India in 82. So today's generation has so much advantage. They can get into the information sector. They can get into the the public domain, the bar, media, bar and bench, the lawyers collective, all those articles, everything. The exposure which they have is phenomenal. Only thing is they must capitalize on it. You must do a lot of reading. You must go and observe the courtroom craft of lawyers. There's something called a stratagem in arguing a matter. You must always observe that. And end of the thing, most important thing is master your brief and make your notes. We don't have the habit, many of us, we don't have the habit of making notes. So we must actually make notes and keep a record of our notes. So 5 years down the line, if you have a similar case, you can say, please refer to that ledger book so and so, and take it off.
I must
say,
hard
work, sincerity, and focus. And don't bother about what the other person is doing. He is flourishing more than me. He is less intelligent, but look at him. He's got big clients. Don't bother about such things. Such things don't matter. So with all that, thank you so much for having me, Jayant.
Thank you, sir. Thank you so much for taking your precious time.
With peace, health, happiness. Please stay safe, healthy, and indoors. Take care.
Thank you. Thank you so much, sir. Thank you for being on our channel. And for all the young viewers, we again thank sir on all your behalf. And please like, share, and subscribe our channel so that more and more people can benefit, not just from the legal sector, but from the non-legal sector. And please take care, wear masks, sanitize your hands. And once again, sir, thank you so much for being on the channel.
Thank you.